So, Pauline, a recent hot topic that our book addresses is what beliefs are protected by discrimination legislation?
Yes, I think you're right. This is a very interesting subject and quite a tricky one, actually. I mean, one of the things that is of interest, I think, and has always, to some degree, puzzled me, is why, if you say you've got a religion, it doesn't matter how obscure the religion is, the court immediately accepts you've got a protected characteristic. But when it comes to belief, there's this test which includes whether the belief is worthy of respect in a democratic society. And of course, that brings into play conflicts of rights, because some people with beliefs, for example, don't approve of people being gay. Very recent case of Forstater, which deals with a person whose beliefs included not approving of trans people, where actually the whole worthy of respect test was properly considered by the EAT. The tribunal at the first instance had decided that the belief was not worthy of respect in a democratic society, but actually the Employment Appeal Tribunal said, well, it is, because it's got to be something really extreme not to be protected. And I think that's got to be right, because, you know, freedom of speech is really very important. And people's freedom to hold beliefs that other people find objectionable, I think, is also important. So I think that's been a very interesting recent decision.
In that case, the claimant's views were gender critical, and the EAT said that they had to be particularly extreme to be outside of protection, comparable to Nazi-like beliefs, and they were those at the top end, the very top end of hate speech. So it means that, to a certain extent, we can believe as long as we keep those beliefs to ourselves, and we can be protected for those beliefs. But I suppose when it comes to manifestation, that's where it's a bit different, isn't it?
Well, I think that's right. I mean, personally, I'm pleased with the decision of Forstater, because as a judge, I've always found it very uncomfortable that I, in some way, was deciding whether somebody else's beliefs were worthy of respect. But I've always thought the real issue is going to be what causes the treatment that's the subject of the complaint. Is it the fact that someone holds a belief, or is it the way they go about manifesting the belief in the workplace, if you like? So, you know, are they saying things about colleagues that are unacceptable? Are they trying to talk people into having the same mindset as them? So I think that's one aspect. And the other thing, of course, is that if the belief is very obscure, does the employer even know that the person holds that belief? So I think I always thought that was the real battleground. And in a sense, Forstater, I think, has moved it further in that direction, from the line of cases where judges were trying to decide, should this be worthy of respect or should it not? So I think that's been quite positive. And hopefully that's put a bit more balance back into the equation, because you're really looking at competing rights some of the time, you know, and everybody has a right to go to work and not be treated badly, and everybody has a right to hold beliefs, but the two don't always match up too well, do they?
Well, that's the thing. So the takeaway point is that even beliefs that are offensive or shocking or disturbing can be protected, but as soon as you start manifesting those beliefs by being offensive or shocking or disturbing in your way you behave, that's when you become the wrong side of the law.
Yeah, I think that's absolutely right. And I think that's a better balance, and it's an easier thing to do than asking judges to make essentially decisions about the value of other people's opinions, which is quite uncomfortable, I think, for a judge or a lawyer. It's uncomfortable territory.